Welcome to the Beneficiaries Corner and our latest course on attorney malpractice. This course will explain some of your rights and options for dealing with attorney malpractice. Let's get started with the facts. To sue for legal malpractice, a plaintiff must prove, number one, duty. An attorney must owe a duty to either a client or an intended beneficiary. Number two, breach. The attorney must have breached the duty to the client by making a mistake that a reasonable attorney would not have made. Number three, causation. The mistake must have a reasonable connection to the harm that was incurred. And number four, damage. There must be monetary damage that has been incurred by the plaintiff. Let's consider a hypothetical situation to demonstrate the problems that arise and the options you have to file a lawsuit based on attorney malpractice. In 1998, Ron and Nancy Smith created a revocable living trust. Under the trust, their current estate was to pass to their three children equally after Ron and Nancy's death. After their trust was created, their oldest son, Jim, had come into a substantial amount of money through work and an inheritance from his wife's side of the family. Jim also was distant to Ron and Nancy and only saw his parents once every couple of years, as opposed to Pat and Linda, who visited their parents regularly. As a result, Ron and Nancy wanted to change their trust to leave everything equally to Pat and Linda and exclude Jim. Unfortunately, Ron and Nancy waited until 2015 to make any changes to their trust. By that time, Ron had begun to show signs of dementia. He was no longer able to walk and could not manage any financial issues. In February 2015, Nancy met an attorney named Bob to draft a trust amendment. Attorney Bob said it would be no problem to amend the trust to exclude Jim. Under the trust terms, the trust can be amended by a writing signed by both settlors. Attorney Bob created a trust amendment excluding Jim from the trust distribution. Nancy signs and dates the amendment on February 22, 2015, but Ron does not sign. In fact, Attorney Bob does not even have a signature line for Ron to sign, and he never tells Nancy that Ron's signature is required on the trust amendment. 2 months later, Ron dies. Nancy then dies in June of 2016. The trust is never amended again. At the time of Nancy's death, the total value of Ron and Nancy's estate is $3 million. Under the original trust, each child would have received $1 million each. Under the amendment, Pat and Linda would receive $1.5 million each. After Ron and Nancy's death, Jim receives a notice and a copy of the trust document as amended. Jim is crushed by being disinherited and immediately suspects that his siblings engaged in undue influence to obtain the amendment. Jim meets with an attorney. The attorney reviews the amendment and realizes that the amendment fails to meet the requirements under the trust document because it lacks Ron's signature. The trust clearly requires both settlors to sign any amendment. Under Probate Code Section 15402, a trust can only be amended by the requirements contained in the trust document. As a result, the trust amendment is invalid. Pat and Linda's lawyer advises them that Jim will likely prevail in his lawsuit because the trust terms were not followed in amending the trust. If Jim does prevail, Pat and Linda will each lose $500,000. What should they do to fix this problem? Here are the options. Number one, sue Attorney Bob for malpractice. File a civil lawsuit in California Superior Court and ask for damages of $500,000 each for Pat and Linda. Number two, file a petition seeking to validate the trust amendment. File a petition in the California Probate Court and ask the court to validate the trust amendment. Option number three, talk to Jim to work out a settlement. Contact Jim and see if you can work out a compromise prior to filing any lawsuits in court. Number four, do nothing. Accept the fact that you're going to receive $1 million each rather than $1.5 million each and call it a day.